Welcome to today's webinar, which will look at changes to the model work health and safety laws in Queensland, managing psychosocial hazards. My name's Carly Hanson and I'm one of the sector sustainability coordinators at Community Legal Centres Queensland. Firstly, I'd like to acknowledge the traditional owners of the land on which we're holding today's webinar. In Meanjin, Brisbane, I'd like to acknowledge the Turrbal and the Yagara people and pay my deep respect to their elders, past, present and future, and acknowledge that these are stolen lands and that sovereignty was never ceded. As today's webinar is being viewed by people across Queensland and throughout the country, I would also like to pay my respects to the traditional owners throughout Australia and extend a very warm welcome to any First Nations people who are joining us today. I'm really pleased today to welcome Claire Gibbs, Principal Lawyer from Maurice Blackburn's Gold Coast practice, who will be covering our session and discussing the new Managing the Risk of Psychosocial Hazards at Work Code of Practice 2022, which has just come into effect on the 1st of April. The code is a practical guide for workplaces and provides an opportunity for community legal centres in particular to review and formalise existing systems for managing workloads and responding to psychosocial issues in the workplace, provide training to staff and managers about their role in identifying and responding to psychosocial risks, and ensure leaders and managers are across these new enforceable developments and ensuring compliance in their centre. So when I hand over to Claire in a moment, she'll discuss the changes to these model work health and safety laws in Queensland, including how the changes will help workplaces to manage psychosocial hazards, an overview of common hazards within the workplace, what's new and what to look out for in the future. So I'll let Claire tell you a little bit more about herself when I hand over in a moment, but before I do that, just some very quick housekeeping. Today's webinar is being recorded and we'll have that recording available for you to download later this afternoon or first thing tomorrow morning. The PowerPoints have been emailed out late yesterday afternoon to everyone who had registered at that time, but if you didn't pick it up off your email, you can download it from the GoToWebinar control panel just in the handout section and also on our website. We really encourage you to ask questions and engage with the webinar today. So you can type your question into the question box on the control panel and we'll read those questions out at the end of the session. Feel free to type them in as you think of them though. Claire will also be running a couple of polls today, so it's great if you can pop your answers into those polls when they appear on your screen. And so without further ado, I'd like to hand over to Claire now to get us started. Thanks so much, Claire.
Thank you, Carly, for that lovely introduction. I would also like to take the time to respectfully acknowledge the traditional custodians of the various lands on which we meet today and the Aboriginal and Torres Strait Islander people listening to this session. I pay my respects to elders past, present and emerging and recognise and celebrate the diversity of Aboriginal and Torres Strait Islander peoples and their ongoing cultures and connections to the lands and waters of Queensland. I acknowledge that this land always has been and always will be Aboriginal land and recognise that sovereignty was never ceded and note the urgent need for a treaty. I know this is probably surprising, a lawyer wanting to talk about themselves, but I did want to explain at the outset why I am really grateful for the invitation and opportunity to talk to you about this topic today. I am a personal injuries lawyer specialist with over 17 years experience. And whilst I don't specialise in workplace health and safety law, I have extensive experience assisting people who have experienced psychological trauma in the workplace. Over the decades I've been in practice, thanks to improvements in safety, there has been a decline, thankfully, in the rates of physical injuries at work. However, for an array of reasons, over the same period, the rates of psychological injuries have increased. And what I can tell you is that psychological injuries can be more pervasive and lingering in their impact. Workers can often make a good recovery from a physical injury, but a psychological injury can be career-ending. Also, I believe that the law should serve everyone, not just those who can afford to pay a lawyer, and I know everyone joining today shares that belief So I feel like I'm among my people, and that makes me a little bit nervous, because I also know that in the legal profession, psychosocial hazards are prevalent, and a combination of them are experienced by us all at some point in time. So I really hope to do the topic justice. First of all, a warning, which is important. Some people might find parts of this content confronting or distressing. If this material raises concerns for you, you can contact Lifeline, or for members of the Queensland Law Society, you can access their free confidential counselling services through its Law Care program. Some of the information in the webinar places an emphasis on data, and as such may appear to depersonalise the pain and loss behind the statistics. But I wanted to acknowledge the individuals, families and communities affected by mental health conditions and suicide. Aboriginal and Torres Strait Islander participants are also advised that there is reference to data relating to Indigenous suicide. Always have to have a caveat as a lawyer. So in today's webinar, I will be focused on the Code of Practice and the workplace health and safety legislation solely. But if a worker is impacted by psychosocial hazard, they may have a course of action under the Anti-Discrimination, Industrial, Information Privacy, Fair Work, Human Rights, Workers' Compensation and Rehabilitation, or Criminal Code Acts. Those causes of action are outside the scope of what I can cover today, but it's important to be aware of those overlapping jurisdictions. So on to the topic of workplace health and safety. Thankfully, you know, the term traditionally, workplace health and safety, traditionally conjured up images of hard hats and hazard tape and safety vests and the like. But the reality is that there are other serious hazards that aren't so visible and as vigilantly guarded against in workplaces. These are the psychosocial hazards. Hazards that lead to psychological injury are not always as obvious or at front of mind for many employers, and risk management strategies and policies are often geared towards simply focusing on physical hazards. To promote greater awareness of psychosocial hazards, protect workers and provide a framework for employers to properly identify and minimise risks, the Queensland Government have created a code of practice for managing the risk of psychosocial hazards at work. And I'll now refer to it as the code. So first, I think it's important to talk about, you know, what's brought us to here and why the code's been brought in. And whilst it might be obvious to state, I think it's still important to point out at the outset the seriousness of the risks in not recognising and managing psychosocial hazards. The risk is death. So some of these statistics, which are really quite sobering, 8.6 Australians die every day by suicide. That's more than double the road toll. 75% of those who take their own life are male. An unknown number of Australians attempt suicide every year, with some estimates suggesting this figure may be over 65,000. Suicide is the leading cause of death for Australians between the ages of 15 and 44. The suicide rate in Aboriginal and Torres Strait Islander peoples is twice that of their non-Indigenous counterparts. People in rural populations are 2 times more likely to take their life by suicide than the rest of the general population. LGBTIQ plus community members report having attempted suicide in the past 12 months at a rate of 10 times higher than the general Australian population. And it's important to recognise, beyond the tragic loss of the person, the impact of suicide deaths are felt by up to 135 people, including family members, work colleagues, friends, and first responders at the time of death. Now, I'm not suggesting that these deaths are all entirely work-related, but what really hits home, how lethal the risks are with psychological injuries, is that suicide is more than double the road toll, and that suicide is most prevalent between the ages of 15 to 44, which is the prime working age in years. Just as not all road deaths are in the course of employment, a high percentage of them would be, and the risk of suicide is double that. The statistics are also consistent in terms of the data that tells us that Aboriginal and Torres Strait Islander people in rural populations and LGBTIQ plus community members are at higher risk of exposure to psychosocial hazards in our workplaces. So in summary, what that data tells us is that it's high time that psychological safety is taken just as seriously as physical safety in our workplaces. On average, close to 8,000 Australians are compensated for work-related mental health conditions each year. Psychological injuries have a longer recovery time and higher costs and result in more time away from work than physical injuries. So on to what's new and what's changed. The code, as Carly mentioned, came into force on the 1st of April this year, and whilst the duty to protect the psychological health of workers and regulating psychosocial risk is not new, the fact that the code is enforceable is new. The code is enforceable through the Workplace Health and Safety Act 2011 and the Workplace Health and Safety Regulations. So for the first time in Queensland, persons conducting a business undertaking, or PCBUs as you'd know them, must take a prescribed approach to managing psychosocial hazards. The code isn't just a guideline to be referred to. Compliance with the code is mandatory, and a failure to do so is an actionable breach of obligations under the Act. So a good place to start or move from here is, what exactly is a psychosocial hazard? The legislation and the code define it as a hazard that arises from or relates to the design or management of work, a work environment, plant at a workplace, or workplace interactions and behaviours, and may cause psychological harm, whether or not the hazard may also cause physical harm. Now, I encourage everybody, if you haven't already, to download and read through the code yourself. I'm not going to go through the code chapter and verse today, but I wanted to give you an high level an overview and summary of what it includes. So the code is broken down into 5 sections, which I will touch on today. The first section is about information about the most common psychosocial hazards. The next section is about who has health and safety duties relating to psychosocial hazards. The third section is about what is reasonably practicable in managing these hazards. The fourth section is about how to go about managing those hazards. And the fifth section is about those other relevant laws that may apply that duty holders should be aware of, which I've already mentioned and won't be covering further. So what are the common types of hazards? I'll give you a quick description and an example of each, and then we've got a poll that Carly's kindly going to help me with. So first hazard is high and low job demands. So that involves things like time pressure, role overload, unachievable deadlines, high vigilance, challenging work hours or shift work, unrealistic expectations to be responsive to people or clients outside of work hours. Low job control, so that's where you're requiring permission before progressing routine tasks, excessive monitoring of tasks and breaks, unpredictable working hours, little or no involvement or input into decisions that affect workers, insecure or precarious work, or work that involves uncertainty over the length of the job, such as casual labour hire or rolling fixed-term contract work. Poor support, that is, poorly maintained or inadequate access to equipment or tools or supervisory support, lack of functional or adequate IT systems, which cause immense stress, limited opportunities to engage with other co-workers during the work shift. Low role clarity. An example would be a worker being told one task is a priority, but another manager disagrees. A worker being given multiple priority tasks from different managers. A worker being given conflicted information about work standards and performance expectations. Poor organisational change management. So that involves not consulting workers on changes in the workplace that affect them, not communicating with workers about the change or genuinely considering their views, lack of practical support for workers during implementation of workplace changes, low reward and recognition. So that's like not being recognised for extra effort or commitment, or no reasonable opportunities for career development, poor organisational justice, that's inconsistent, unfair, discriminatory or inequitable decisions and applications of policies or procedures, poor workplace relationships including interpersonal conflict, so that involves unresolved and excessive conflict regarding work tasks, processes, customers or interpersonal issues between staff, remote or isolated work, so examples in the code are farmers, a community nurse conducting visits at night, night shift operators in petrol stations, fly-in and fly-out workers, workers who spend a lot of time travelling, for example, driving, workers working alone from home or socially isolated away from home over protracted periods of time. The next hazard is poor environmental conditions. So that's work environments that involve poor air quality, high or nuisance noise levels, extreme temperatures or uncontrolled biological hazards that impact on mental health. Traumatic events, which is a really, really big one, particularly for a lot of lawyers. So that involves investigating witnesses or being exposed to traumatic events. This may include reading, hearing or seeing accounts of traumatic events. And so, yeah, and again, it's not just being directly witnessing, it's, investigating fatalities, serious injuries, investigating abuse, neglect or serious incidents, investigating child protection cases, being exposed to extreme effects of natural disaster or seriously injured people. The next other one is another really prevalent psychosocial hazard, violence and aggression in the workplace. So that involves biting, spitting, kicking, throwing objects, using or threatening to use a weapon, verbal abuse and threats, aggressive behaviour such as yelling or physical intimidation. Bullying is another hazard and a common one. I will go into bullying separately a little bit later, but that involves repeated incidents of practical jokes or initiation, spreading misinformation or malicious rumours, belittling or humiliating comments, being verbally denigrated or threatened, and harassment, including sexual harassment. So that's harassment in relation to personal characteristics such as age, disability, race, sex, relationship status, family responsibility, sexual orientation, gender identity, or intersex status. So now we're giving some of the examples of each of these hazards. Carly, and we'll get you to run the poll. I'd like to see which, if any, of these common categories do you feel like you're most exposed to in your work?
Thanks, Claire. Everyone, you should see the first, we've had to split it just because of the software restrictions into two parts. So we'll go through the first 5 or so categories that Claire has mentioned first. So you can tick more than one box here. So high or low job demands, low job control, low role clarity, poor support, poor organisational change management, low reward and recognition, or poor organisational justice. And then we'll have an opportunity to do the next batch in a moment. So I might just give you another 10 or 15 seconds to pop your answers into those boxes, and then I'll close the poll. All right, I might just 5 more seconds and then I'll close up that poll. That's great. Thanks, everyone. So I'll just share the results of that one so we can just have a quick look. So hopefully, Claire, you can see that as well, about 74% in the high and or low job demands. And then our next one is around poor support or poor organisational change management.
Oops. Yeah, that's telling and not unsurprising. Is there another one now, Carly?
Yeah, so here's the next bundle of common categories there. So that should be displayed on your screen now. So I'll give you a minute to complete that. So traumatic events is coming through as a strong response so far, and poor workplace relationships, including interpersonal conflict, violence and aggression, around the same amount. So I'll give you another few seconds to complete that, and then I'll share those results as well. All right, thanks everyone. You should see that second part of the poll now displayed on the screen. So Claire, a strong winner there around traumatic events at 71% for our audience today.
Vicarious trauma is a high risk for us all. So hopefully, yeah, with all of those things in mind, as we move through the rest of the webinar, thinking about those things, if you do have sort of leadership responsibilities, or if you are experiencing these sort of psychosocial hazards in the workplace, hopefully, as I take you through how the code works, it will sort of make more sense to you and have some sort of practical impact and some things for you to take away. So again, who has a duty? And it's important to recap on these things. This duty, the duty is to, as far as reasonably practicable, ensure the health and safety of workers in the workplace, and that includes psychological health. So this duty isn't new, but these are the duty holders essentially. So a person conducting a business or undertaking, so a PCBU, the code and regulations apply to all work and workplaces covered under the Workplace Health and Safety Act. The code and regulations cover employers, workers, contractors, subcontractors, outsourced workers, self-employed, apprentices and trainees, work experience students and volunteers. The code and regulations also cover other people in the workplaces such as customers and visitors. And but the code and regulations do not apply to some Queensland workplaces in the mining and resources industries and Commonwealth government departments and Australian public service agencies. Queensland mining and resourcing workplaces have separate health and safety laws. So what are the duties of officers? So an officer of a PCBU, a company director, senior manager or executive must exercise due diligence to ensure PCBUs comply with duties under workplace health and safety laws. And an officer's duty is immediate, positive and proactive, and is owed by each individual officer of a PCBU. So there are duties of workers, and there is a big focus of this in the code. So it's important to cover what the actual duty of a worker is. While at work, a worker must take reasonable care for their own health and safety, including their psychological health, and take reasonable care to ensure that their acts or omissions do not adversely affect the health, including psychological health and safety of other persons. Workers need to comply so far as the worker is reasonably able with reasonable instructions given by a PCBU, and they need to cooperate with reasonable health and safety policies or procedures issued by a PCBU that have been notified to workers. So, for example, workers must cooperate with reasonable policies relating to workplace, work-related bullying, work-related violence and aggression, sexual harassment, or other forms of harassment. Workers also have a role to play in managing psychosocial hazards and creating healthy workplaces. The code encourages reporting of concerns about psychologically unsafe work environments and participation in safety initiatives. The code both provides helpful guidance to employers to comply with their obligations, but it's also actually a helpful resource for workers who may be experiencing psychosocial harm at work. I'll talk to this a bit later about how this might assist a worker to exercise their rights to refuse to take on additional work. So what is reasonably practical under this duty? Reasonably practical in relation to a PCBU's duty is to ensure health and safety means that which is, or at a particular time, reasonable to be done to ensure health and safety, considering and weighing up all relevant matters, including the likelihood of the hazard or the risk concern occurring, the degree of harm that might result from the psychosocial hazard or risk, the availability and sustainability of ways to eliminate or minimise the risk, what the person concerned knows or ought reasonably to know about the hazard or risk, and about the ways of eliminating or minimising the risk. After assessing the extent of the risk and the available ways of eliminating or minimising the risk, the costs associated with available ways of eliminating or minimising the risk, including whether the cost is grossly disproportionate to the risk. And we'll have a practical example of how this might work a little bit later on. But the next part of the code is really, and helpfully, I think, about consulting workers. So there's the 3 C's. PCBUs must show that there's consultation, cooperation and coordination with workers. So they must consult as far as reasonably practicable with workers who carry out work for the business or undertaking and who are or are likely to be directly affected by hazards. The term workers includes, again, anyone carrying out work in any capacity for the business or undertaking, including contractors and their employers, labour hire workers, apprentices, trainees, work experience students and volunteers. So it has a large reach. So examples of consultation include focus groups, worker surveys, workplace health and safety committee meetings, consultative committees, or team meetings, or individual discussions. So there's lots of ways open and means open to a PCBU to properly consult with workers. The procedures for consultation must be decided in consultation with workers, and if there is an agreed procedure for consultation, that procedure must be followed. And I'll speak to an example of what this might look like in practice shortly. So how this all works. So the code outlines a 4-step process for managing risk. The first is to identify the psychosocial hazards. The second is to assess those risks. The third is to control, where possible, the risk of psychosocial hazards. And the fourth is to maintain and review any control measures that have been implemented. So essentially what employers must demonstrate is that they can manage hazards and risks in a way that provides a standard of health and safety that is equivalent to or higher to the standard required under this code, or they'll risk penalties. The code reflects the growing recognition of the serious impact the workplace can have on mental health and emphasises that employers must have in place appropriate and comprehensive policies and risk management strategies, and that they regularly review measures to ensure they remain effective. The risk management process is continuous and employers cannot just set and forget. There's also an increased emphasis in the code, as I mentioned, on consultation and communication with workers to ensure that everyone is aware of the potential risk and everyone's also aware of what measures are in place to attempt to protect them. So the first step under the 4-step process is to identify the hazards. Now, you might think that this speaks for itself, but there is a lot of guidance in the code, which is very helpful for employers and even for workers to properly sort of really identify the real true risks that they face in the workplaces. So PCBUs must identify reasonably foreseeable psychosocial hazards that could give rise to risks to health and safety. And these are hazards that arise from or relate to the design and management of the work environment, the plant at a workplace or the equipment, and workplace interactions or behaviours. So these are social factors at work, and the way that workers interact and behave, including bullying, work-related violence and aggression, sexual harassment, and other forms of harassment, such as harassment due to age or disability or race. So there's really helpful guidance in the code about how you identify workers, but again, this is probably sadly identified in the statistics I spoke to earlier, but the code specifically sets out and identifies workers who are at greater risk. So the examples of workers who are at higher risk include workers with limited work experience, so younger workers, apprentices or trainees. I would probably add volunteers into that category. Workers who have barriers to understanding safety information, so literacy or language barriers. Workers with perceived barriers to raising safety issues, so workers engaged in insecure or precarious casual work. Workers with certain attributes, so such as sex, race, religious beliefs, pregnancy, gender identity, sexuality, age, or a combination of these attributes, and workers with an injury or illness preventing them from performing their full or normal duties. So it won't be disputed now that employees know that these particular categories of workers are at higher risk, and it will be the case that they can't plead ignorance. Control measures will need to be put in place to protect these vulnerable workers. Mentioned going back to bullying before, this is an excerpt directly from the guide, and this is consistent with what we see under the Workers' Compensation and Rehabilitation Act, that employers will say it's not bullying if it falls within the category of reasonable management action. This is the main barrier to injured workers accessing compensation for psychological injuries, and probably a topic I could talk about for hours, but I won't. And whilst I'm never one to stick up for employers, it is important to note that psychological injuries still occur in workplaces where best practice and good control measures are adopted. So if a PCBU can prove that they had good policies and control measures in place and they appropriately responded to complaints, then they will comply with the code. The next step in the process is to assess the risk. And again, this might speak for itself, but I think it's important to cover up on the actual steps that employers need to be taking and PCBUs need to be taking. So a risk assessment, multiple or dynamic risk assessment, should be carried out for any psychosocial hazards that have been identified in step 1, where the risk of hazard or accepted control measures are not well known. This includes when there is uncertainty about the likelihood or severity of consequences, how a psychosocial hazard may result in injury or illness, how psychosocial hazards may interact or combine to create a new or greater risks, how changes at work may impact the effectiveness of control measures, or ways of eliminating or minimising the risk. Many have been involved in conducting a risk assessment, but there is excellent guidance under the guide. But what I think is important for you to take away is that to assess the risk of harm from psychosocial hazards, PCBUs need to identify the workers and others likely to be affected and consider the duration, so how long are workers and others exposed to those hazards, the frequency, so how often are workers and others exposed to the hazards, and the severity of their exposure. So how stressful do workers find the psychosocial hazard to be? And how psychosocial hazards may interact or combine to increase the risk. So we even know from our poll that, you can be experiencing one or more psychosocial hazard at the same time. So sometimes it's not just one risk on its own. If there is a combination of multiple risks, a worker will be at greater risk of harm. So where to and what to look for in relation to identifying these risks. And I think this is probably one of the most helpful parts of the code in giving guidance about where to look to identify these trends and patterns. It's very important because psychological and mental health issues aren't often reported enough. So it's helpful to establishing the standard of care and scrutiny an employer must demonstrate in identifying risks. In my view, the excuse of, well, we haven't had any complaints can no longer wash. there's excellent guidance about, workers that are at heightened risks and types of work where people are at greater risk of psychological harm. I'd also suggest that where you have a client who has experienced psychosocial trauma in the workplace, then investigations and discovery, you ask for disclosure of some of this information. So what to look for? So records of leave, you need to look for increasing rates of unplanned leave for the work unit, region or department compared to the whole organisation. And you look at excessive or unused recreational leave balances or patterns of use, such as frequently taking unplanned leave, which could be associated with unpleasant working conditions and work-related stress. The hours of work, look at any data related to unplanned hours, actual hours of work that may cause fatigue, excessive overtime, shifts that are not well managed, or not taking rest breaks during shifts. I don't know how many of you don't take a lunch break, but I think that there should be a survey about that, particularly in the legal profession. Looking at workers' compensation claims, so patterns and trends for recorded compensations claims and information that you can glean from them about psychosocial hazards and risks in a workplace. Any increasing rates of psychological injury claims or increased severity of psychological injury claims. And it's important to look at the mechanisms of injury associated with each particular psychological injury claim in terms of a broader overview of the data and the actions taken in the workplace to prevent further injury or illness. Grievance information, so looking for records in relation to grievances at work that indicate conflict, organisational injustice, lack of role clarity, harassment, discrimination, work-related violence and aggression, and work-related bullying. In a lot of workplaces, it's one of the first things that we look for when we're investigating a claim to somebody with a psychological injury is usually if there is a bully, they have form, and employers have access to this information. So the severity of the frequency of grievances is an important one to look at. Incident and injury records, that probably speaks for itself, but you look at those dates and times and see if they coincide with other events or trains. Employee assistance program, it's really important. It is a confidential service, but what PCBUs will have is access to summary data, such as uses for types of issues, which can indicate either positive or negative trends in a particular workplace. Minutes of meetings, so you can look for unresolved and reappearing worker issues that occur over a time, such as workload, and complaints about changes in work roles and workloads, and this can be reviewed like with toolbox talks or staff meetings. Workplace surveys, so it's important that that staff are regularly surveyed so that they can look for dissatisfaction about leadership or management styles or managing conflicts at work. Turnover data, exit interviews are an excellent source of data, so looking at what is causing a larger than normal turnover rate, reasons for why people are leaving, particularly if that includes workload or lack of support or the mention of any bullying, conflict or organisational justice. It's the perfect source of really quality of information and data. And recruitment is a good one to look at. So looking at the difficulty or ease with which new workers can be recruited, the time taken to hire compared to industry averages, and any reviews posted by current or former workers or organisational review websites that mention workload, bullying or support. And it's important, particularly in relation to occupational violence and assaults that are occurring at an alarming increasing rate, looking at data about the frequency and severity of risk of violence in the local community where the PCBU is located. So this is the hardest step of the 4-step process is how do you go about controlling those risks? So PCBUs must, where they can, minimise the risk of psychosocial hazards by either substituting or isolating the hazard from a person or implementing engineering controls so as far as reasonably practicable. And this can be done through good work and system design. I'm going to speak to it in a little bit more in a minute, but when I refer you to the guide, there's excellent examples of control measures that might be applicable to whichever psychosocial hazard you identify in your workplace as most prevalent and at highest risk. So there's some excellent guidance in Appendix 4 of the code, which I encourage you to have a look at. So from the code, I've selected an example that I feel is pertinent, and it makes me, after that poll, even more confident in feeling that it's pertinent to the legal profession and the suggested control measures. Now, whilst this looks great on paper, the reality of practice and the unpredictability of the work, or the clients coming in the door, and the lack of resourcing make some of these control measures difficult to implement. But I encourage you, as I read through the suggestions, to think about how this might have the potential to minimise the risk of burnout for you and in your workplaces. So the suggested control measures, which is sometimes easier said than done, is design the work to ensure manageable workloads with achievable performance standards, implement self-check-in processes for customers and patients to reduce staff workloads, rotate tasks and activities so that workers are not overexposed to time-pressured or excessively demanding work, negotiate reasonable deadlines for completing tasks, provide workers with sufficient time, resources and appropriate equipment to perform the tasks assigned, schedule regular breaks throughout the day and ensure workers are taking those breaks to get adequate rest and support. Again, I'd like to survey how many people in the legal profession are regularly taking their lunch breaks and having those resets. Monitoring and managing workloads through peak periods of demand. So that could be end of financial year or seasonal peaks leading into, the end of the calendar year. And use this information to plan and provide additional resources where required. Ensure work tasks are matched with the worker's capability level and nobody is drowning. Ensure sufficient cover for workers who are on leave, and and allow people to properly take their leave and have a holiday and a break without being contacted. Implement flexible working arrangement policies and practices, which I hope everybody is having access to and using and utilising. Implementing workload reporting and review systems and scheduling regular opportunities to review workloads with staff, and encourage work practices and systems that allow workers to disconnect from work outside of work hours. Yes, all looks great on paper and we'd love to implement all of these things, but it is, and hopefully with the code, with the greater awareness of the risk of harm from psychosocial hazards, that these types of things won't be just something that's a bit of a guideline and yes, that's best practice, but things that become part of workplace culture moving forward. And then once you've, put steps in place to control the risk and to control measures, the next step for a PCBU is to ensure that they monitor and review the tasks. So again, you cannot set and forget. And there was a case of Armstrong Waters that Maurice Blackburn successfully ran for a nurse, which comes to mind, and he was assaulted by an aggressive patient in an emergency department. And the injury was, of course, caused by a criminal act of the patient. He assaulted our client, but we argue that our client was not provided with adequate aggressive behaviour management training. And had this nurse been provided with this training, he would have managed the situation differently and avoided injury. Now, not surprisingly, Queensland Health strongly contested liability in this claim and provided evidence that our client had been provided with some aggressive behaviour management training. But what they couldn't show was that this training was ongoing, and it was essentially held that, once isn't good enough. Given the prevalence of assaults in the workplace and the significant and foreseeable risk of injury to workers, it was held that regular, continuous, refresher, aggressive behaviour management training should have been provided. And their PCBUs will need to be able to demonstrate the risks identified and control measures are regularly reviewed to determine that they continue to be effective. So that's essentially the 4-step process that's set out in the code. Now we've talked about what's prevalent for you in the workplaces by way of psychosocial hazards. I'll get Carly to start running the second poll, but I want you to have a think about hazards from your clients or community perspective, and which of the common categories are your clients and community most exposed to?
Thanks, Claire. You should see that poll up on the screen. And again, we've split this into 2 sections. So you've got the first bundle of hazards up on the screen now. So I'll give you another 30 seconds to fill your responses in there. So just another 10 seconds to get your responses in if you can. And I have just realised it's only going to let you choose one rather than multiple responses. So that's my fault. Sorry about that, everyone. Pick your best response. All right, I'll close up that poll now. Thank you. And you should see those responses on the screen. So around 29%, so the highest area was around high or low job demands for clients and community, and then low reward and recognition, followed by poor support or organisational change management.
Great. I'll get you to get to that second category, Carly.
Okay, fantastic. That should be on your screen now. So then the next bundle of categories for clients and community. And again, it's just going to let you pick one response for this one. So just select what you think is maybe the most common for you. I'll just give you another 20 or so seconds to pop your response in. All right, fantastic. I might close that one down as well and share those responses with you. So you should see that one on the screen now. So again, traumatic events is a clear standout as the most common category, followed by poor workplace relationships, including interpersonal conflict. I'll hide those responses and back to you, Claire.
Thanks, Carly. That's really insightful for me. Sorry, I'll just try and move on to the next slide. For me, yeah, actually, I'll move to this side and I'll get you to have a look at this as I'm speaking to this, because there's a little bit in this. But for me, on the Gold Coast, health and education are two of our largest employers, and in health in particular, health workers are being assaulted at alarming rates. The physical injuries, as I said before, typically either resolve or they make a good recovery from. But again, the psychological trauma can be career-ending. So this is an example that on the screen here from a Gold Coast hospital, and it's a draft risk profile that has been circulated to workers for consultation and feedback. And I thought it was helpful to have a look at this and how this might actually, how it's now working in practice, or what PCBUs are doing to implement the codes and follow the guidelines. In terms of consultation with workers on this one, it's been pleasing to see that there's been multiple forums that have been set up at different dates and times where workers can either join inline or online or in person. I'll just go to the second part of that that risk profile, and again, if you can read through it as I'm talking to it, but you'll see that the risk of abuse and assault is rated as high as 12, this hospital is noting that the current control measures are partially effective, and even with further additional controls, you'll see in the last section, the likelihood of the risk occurring is still high, but it's rated at 9. And in my view, that's realistic, because particularly with assaults and public-facing work, employers can put every conceivable control measure in place, but criminal activity can still occur. However, it is, there's still things that can be done, and bringing the risk level down from 12 to 9, if that goal is achievable, will make a significant and measurable difference. The note I do want to make about this example is the proposed mental health training as a control measure for all staff. And that's noted as, recommended pending funding. I hope that that funding comes through. You'd assume that a great number of staff would have general first aid training, and for some it would be a requirement for the job. Given what we know about the heightened risks of psychological trauma, in my view, this mental health first aid training should become a new minimum benchmark. So how is the code enforceable? You're probably thinking. Again, it is brand new, so I don't have any examples of any sort of penalties or prosecutions at this stage, but the code is enforceable in the same way any breach of workplace health and safety legislation is enforced. If a worker makes a complaint, it will be investigated, and if substantiated, an employer can be issued with an improvement notice, prosecuted and fined. I think it's also arguable that if a breach leads to suicide, it could lead to an industrial manslaughter charge in very serious cases of psychological harm. However, again, it's important to recap, if a psychological injury occurs or a complaint is made, employers must then be able to demonstrate that they can manage hazards and risks in a way that provides a standard of health and safety that is equivalent to or higher than the standard under the code, or risks those penalties. Employers must have in place an appropriate and comprehensive policies and risk management strategies, and again, regularly review those control measures to ensure they remain effective. The risk management process is continuous, and employers, as I mentioned, cannot just set and forget. There is also the increased emphasis in the code, as I mentioned, on consultation and communication with workers to ensure that everyone is aware of the potential risks and, again, aware of what the measures are in place to protect them. My great hope with the code is that it isn't a toothless tiger, but in addition to the code, it will take a mindset shift and greater awareness and reporting of psychosocial issues in our workplaces. If you do a search or try to do a search of prosecution, you'll have to look really hard to try and find a reported decision about a psychological injury prosecution in Queensland. But with greater awareness about the code, I'm hoping this will lead to greater reporting, and that the Office of Industrial Relations follows through and throws the book at any PCBUs who fail to comply with their obligations and fail to comply with the code. So what this all means for you in practice, again, it is brand new, the duty hasn't changed. But firstly, for you as a worker, the legal profession is its own beast. Practitioners often work in traumatic conditions, as we've all identified today, juggling client demands, pressing deadlines, long work hours and large file loads. And by the inherent nature of the job, lawyers are at high risk of being exposed to psychosocial hazards in the workplace. Nonetheless, for far too long, many of us have worn this stress like a badge of honour, as a symbol of productivity and a strong work ethic. Because of the historically adversarial nature of the legal practice, some of us fear an admission that if you admit to high levels of stress or depression, this will be seen as a sign of weakness. It's time for that to stop, and for us all to closely guard our mental health and wellbeing and raise these issues and lead change. The code is a step in the right direction, but a cultural change is what is the ideal control measure in my view. It's also to remember your obligations and duty as a worker yourself to take reasonable care for your own health and safety, including your psychological health, and your duty to take reasonable care that your acts or omissions don't adversely affect the health and safety of other persons in the workplace. So if you're in a situation where you might be confronted with a work environment or task likely to cause you psychological harm, you can refuse to subject yourself to that based on your duty to take reasonable care for your own mental health and wellbeing. So in the spirit of wanting to see cultural change and wanting to see the invisible become visible in our workplaces, I'm going to share with you all a very personal example, because I am among my people and friends today. Just over 2 years ago, a family member of mine tragically drowned. And 12 months later, I was back at work and I received an inquiry to advise someone who was injured in a failed rescue attempt of someone that had drowned in the surf. Now, this person was a direct referral to me and specifically said that they wanted me to be their lawyer and to act for them. I immediately felt drawn to wanting to help them and felt deep empathy for everyone involved. But I knew this would be triggering for me and it would impact my mental health. So I advised my supervisor that I couldn't take this on, and I arranged for another lawyer to provide advice. And so if something, and that's why, again, I encourage you, and it's going to take a cultural change, but if something is triggering for you, feel confident in not taking it on and knowing that it's actually your duty to safeguard your mental health. So this is what I think it means for us in practice as a worker, as a duty holder. It's likely that your organisation already has risk management systems in place to manage current workplace health and safety hazards, and hopefully good policy and training about how to operate a trauma-informed practice. However, a review of current policies and practice against the code is encouraged to ensure you are adequately managing psychosocial hazards in the workplace. Again, remember, it's not set and forget, so regular reviews are required and those reviews need to be documented. The QLS actually has some recommendations for control measures specifically for lawyers in relation to vicarious trauma that we were speaking about before. And some of those baseline control measures recommended to ensure employees who are exposed to traumatic events or material have adequate means of support and counselling, and provide them with the opportunity to undertake a variety of work that does not contain traumatic material if possible. The other control measures conduct regular check-ins with remote workers, which is really important from the vicarious trauma point of view. You know, you need to be, as a duty holder, reporting and admonishing violence, aggression, bullying and harassment, including sexual harassment in your workplaces. Ensure that there's access and regularly promoting the employee assistance programs for all employees, allowing employees flexibility from work from home on dedicated days to ensure more time outside of work for better sleep, exercise and social connection with family, friends or the community, and appointing and conducting training for workplace health and safety officers on psychosocial hazards specifically. And this is a recommendation that I really, I think is an excellent one, is appointing a specialist workplace health and safety psychosocial hazard officer. And their role is to monitor and conduct the ongoing risk assessment and consult with workers about specifically psychosocial hazards. And so lastly, what I think it means, in my view, my final observations about what it means for your clients and community is hopefully that the code's going to achieve its objectives in promoting greater awareness of psychosocial hazards and protecting workers. Workplace health and safety laws have historically been underutilised, in my view, to protect workers from psychosocial harm, and that's evident in the very low levels of reported prosecutions. It's important to empower our clients to feel comfortable to comply with their duty, to take reasonable care for their own mental health and safety, and assist them to speak up and hold their employers accountable to do the same, and actually start making complaints to workplace health and safety to call out breaches of the code in appropriate circumstances. The code is a step in the right direction, but that cultural change that I spoke about earlier, that starts with us. So that'd be my final observation. Are there any questions, Carly?
Thank you so much, Claire, and thank you for sharing your personal experience as well. I feel like many people on the line probably have had similar kinds of experiences in their working lives. So it is, you know, it's good to be able to share that with each other and learn from your good practice around that. So there have been some questions that have come in. I do recognise that we're at 3 o'clock, but Claire has generously agreed to stick around for a tiny bit longer to get to at least a couple of your questions. So firstly, someone has asked, how can workers bring this issue up with management? So I think you've spoken a little bit about the various duties of workers and duty holders. But if managers are not taking the issue seriously, what else can the worker do?
That's a good question. There's actually in the code as well, and I didn't speak to that, there is a dispute management process about how these things should be raised and how PCBUs need to be responding to complaints. And if a worker feels like it's not adequately addressed, that the ways to escalate it internally within the organisation. That's what I spoke to before, is particularly with repeat offenders, bullies that are, in senior management, it is a really awful sort of, the workplace itself is just a psychosocial hazard from start to finish because of those things. It is the case that I would recommend making a complaint or seeking the advice through workplace health and safety. So it's the same as making a complaint or seeking advice or assistance or seeking an investigation in relation to a physical injury. On the workplace health and safety website, there is a drop-down menu where it talks about, have you experienced, an injury or a hazard in the workplace? Do you want to report it? And then there's a drop down about, is this a psychosocial hazard? And then there's someone that you can talk to immediately within the department about that particular psychosocial hazard, and they can give you some guidance as to how to escalate it too. So that's what I will be encouraging my clients to do, or any colleagues in a situation, particularly with psychosocial hazards where it is management that are bullying you. You're not really going to get anywhere within the organisation. So there is that mechanism now to report that in that drop-down menu. So I'd encourage people to really sort of look at seeking the assistance of the department and making those complaints, because as I mentioned, like even researching this presentation, I found it really, really hard to find any reported decisions or documentation in and around, complaints and how they'd been investigated and how they'd been prosecuted.
Thank you. So I've got another person who's provided a bit of a scenario, saying in their service they're seeing increasing numbers of clients engaging in hostile behaviour, which is making it hard for the workers to provide services. This person's wondering, what is the best way for organisations to collect data to support changes in how to manage clients while looking after their staff?
So sorry, I missed that first part. How was the behaviour described? Sorry.
So hostile behaviour from clients. So I'm not sure what that might involve, but potentially, if it's a phone service, clients becoming aggressive or yelling on the phone, or if it's in person, perhaps doing similar kinds of things, perhaps also physical threats or abuse. Yeah, it hasn't been defined here, just hostile behaviour.
Well, that hostile behaviour, yes. So that's a really important one, and it does really speak to it in the code and the guidelines for practice about those ways to identify. But in terms of data collection, it's really sort of consulting workers about those aggressive behaviours. And again, it probably, in my view, like there are ways you can ask workers for that information, but sometimes it's not provided as well. And if it's inherently part of the job and you're constantly having those hostile workers, that should be been identified as a significant and high level risk if that behaviour is continuing to happen. But in terms of collecting the data, well, the consultation piece in the guide is really, really important. But there is, in terms of, it does speak to specifically in the guide just levels of activity, in particular public facing roles, so customer service roles, call centre operators are one that are also identified at high risk as well. So it may not be that you need the data to prove that this thing is happening, because employees should be, if they aren't aware, they ought to be aware. But in terms of consultation, there's those pulse surveys, forums, those types of things, in identifying the risk and properly sort of categorising that risk as high risk. But again, yeah, short of that, it's that cultural change in making sure that people are feeling comfortable about reporting these things. If they, if there are hostile workers and it is happening, it shouldn't be just part of the job that people have to accept.
And a follow-on from that question is that some workers might minimise client behaviour, so they're acting stoic or making it seem like the behaviour is not as serious. So I guess there's questions perhaps around workers' different views or levels of tolerance of this this kind of behaviour, and how that might impact how the PCBU acts on it or to prevent the behaviour or to control that hazard.
I 100% agree with that observation and the difficulty with it, because they are silent things, and you know, there's different levels of resilience in the workplace, you know, different levels of experience as well, and different levels of, you know, if they're like hostile behaviours, you know, one could be extremely hostile or could be just, you know, undermining, you know, just nitty gritty type of, you know, hostile behaviour day in, day out that adds up over a period of time. But what the code does say is that employers and PCBUs have to try and look behind that. If you're in a high risk area or doing high risk type of work, it's looking at, well, what are the patterns? So, you know, they might be reporting, but looking at the EAP data to see if that people are reporting issues there at a higher level in terms of general categories. Looking at, yeah, sort of leave records, whether people are taking leave or not. And, you know, like, so some of those behaviours where people are sort of disengaging as well is taking that extra step of, you know, if someone is a high performer and, you know, they don't tend to complain, but you do notice that those types of things are impacting their employment in different ways. I think what, you know, with this greater awareness with the code is PCBUs needs to dig a bit deeper and have a conversation with that person to look at those behaviours. So it is a hard one. There isn't a one size fits all. But if it is a high risk and it's a behaviour or a hazard that is commonly happening or highly prevalent, you have to do everything that you can to look behind, not you consult workers, but look behind what data you can sort of get your hands on and have a deeper dive.
Thank you. And I might just do sort of one or two more short questions, and then we can wrap up and let Claire get back to her work. So this question that's come through is, how do we as employers determine on a daily basis workloads for employees? Would you suggest a check-in every morning to determine what each employee has on for the day and what they might be able to handle?
It's definitely not a one size fits all. And as an employee, like, you know, as a manager and as a leader myself, you know, looking at workloads, it is, you know, and it depends on the level of seniority of staff as well. So there's so many factors that go into that, but it has to be that you sit down and you have a system of regularly reviewing it. So it might be the case that, you know, again, it's not set and forget, and things change and happen. People can go on leave, people leave employment and end up with a bigger file load. But when you know that, like, certain events were triggering higher file loads, I think that's when, as an employer, as a supervisor, as a mentor, and as a leader, you need to be, you know, aware that, you know, there are those peak periods that I spoke about, like leading into Christmas, sometimes, you know, end of financial year, for other lawyers, that there are these really peak periods, and looking behind those things and making sure that those control measures are in place. So no one's saying, you know, like, there's never going to be the case where people are going to be twiddling their thumbs at work. That it's not going to be the case at all. But when it is, you know, excessive, sometimes it will be a temporary thing, and as long as you're communicating with the worker or the lawyer or whoever it is, the case manager, that this is temporary, these are support measures that we've got in place. But, you know, as people get more experience, if you've got a baseline that you work out about, you know, what someone can reasonably handle, and then, you know, looking at, you know, if it's getting outside or you know, below capacity, just regularly reviewing that and checking in. But there isn't, I wish I had a simple answer for you, but there isn't a one size fits all, other than to be aware of those times when you know that workload can really increase in around those peak times, or, you know, transitioning between lawyer to lawyer or staff members.
Fabulous, thank you so much. There are a few more questions, but unfortunately we are at time, and a couple of the questions have also been sort of answered across Claire's session. So I hope that everyone has found that really helpful, and you know, we'll trigger some review of work health and safety policies and risk management policies and frameworks within your organisations. So I will now say thank you so much again to Claire Gibbs from Maurice Blackburn for presenting such a comprehensive session today, and thank you all for your questions. They were really helpful, and I will just encourage you to complete the very short feedback survey at the end of the webinar, which will pop up on your screen automatically once I close it down. So thanks everyone, and take care, and we'll see you for our next session.